Hi everyone, we've reached the final part of our series on reasonable adjustments. We started by identifying when that duty would apply. We then moved on to the factors that have taken into account in determining the reasonableness of an adjustment, and that has then flowed through the case studies that we've given. So the Equality and Human Rights Commission have prepared a very detailed guide to the Equality Act, and within that we have factors that may be taken into account in assessing the reasonableness of an adjustment. Now, we've talked about regular breaks, we've talked about displacing employees. In this case, it's not one of my own case law examples from my experience, but it is a case which did reach the Employment Appeals Tribunal, and that is on protecting salary. Now, this does arise quite regularly in circumstances where an employee wants to get back to work but may not be able to perform the same job or the same scope of duties as they were before. And often we get a request to say, well, I can come back in a slightly abridged role or a more junior one, but I want you to protect my salary as part of that, and it's a reasonable adjustment to do so to stop me suffering any substantial disadvantage. So in the case that we're going to discuss, this is an individual who is a science teacher, could not continue in that role due to a mental impairment, but could work as a cover supervisor. And the crucial issue here is that the supervisor position attracted a lower rate of pay, and the employer put an adjustment in place as a temporary measure to the extent that they could perform the supervisory role for a 3-month trial period, and that would be at the higher level of pay, so they would maintain salary protection for that time. 3 months was indicated as a reasonable period of time because that would allow the employee to at least get back to work and trial the position. It would also allow the conclusion of an internal grievance which the employee had raised. So after that 3-month period had elapsed, the employer commissioned a further occupational health report, which is absolutely the right thing to do. That report suggested that the employee was not going to be fit in the foreseeable future at any time to return to their post as a science teacher. On learning that recommendation, the employer suggested that if the employee was to continue in the lower supervisory role, they would have to take the lower rate of pay. The employee in those circumstances brings a claim in the Employment Tribunal, arguing that the decision not to pay at the higher rate of pay and maintain that higher salary was a failure to make reasonable adjustments. This case went to the Employment Appeals Tribunal, who determined it was a reasonable adjustment to maintain the higher rate of pay during this 3-month probationary period, and whilst the work processes were being carried out, so the internal grievance process. And that I agree with. That particular step was effective in preventing the disadvantage, so the disadvantage being that the employee couldn't return to work, and the full pay at least got them into a job and started supporting them in determining whether they could make a more substantial return. Those considerations, however, ceased to apply, so the employee was back at work and they were being integrated back into the organisation, and the grievance was concluded. There was a significant additional cost involved in continuing to pay at the higher rate of salary indefinitely. The employer reduced evidence that they were suffering financial pressures at the time, and again we're looking at the EHRC factors there around the financial and other costs of making the adjustment, the extent of the employer's financial resources, and the type and size of the employer. There's no doubt, as I say, that the step would have been effective, but the cost implications in this case were one of the most significant factors that the tribunal took into account. They also confirmed that because the occupational health report had stated the employee is not going to be able to return at any point, the effectiveness of that adjustment is then called into question, because ultimately the employee is never going to be returning to the post that the adjustment was suggested for. It also probably would have caused disruption and implications elsewhere as well, because other individuals working as a cover supervisor may raise concerns themselves that somebody's being paid indefinitely at a higher rate for performing exactly the same role. So protecting salary is potentially a reasonable adjustment to make. In this case it was only a temporarily acceptable adjustment, but all factors again do have to be taken into account, and it really was important that the employer could adduce evidence on the cost implications, its own size and resources, and the impact that that adjustment would have if it was implemented indefinitely. So we've gone through three fairly technical examples of different adjustments which could be made. If you do need any support in this very difficult area of law, or anything relating to employment law generally, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.